Welcome to this article on the Prevention of Money Laundering Act 2002. The Prevention of Money Laundering Act, or the PMLA Act 2002, is an act of the Parliament of India enacted by the NDA government to prevent money laundering and to provide for confiscation of property derived from money laundering. PMLA and the rules notified thereunder came into force with effect from July 1, 2005. The Act and rules notified thereunder impose obligation on banking companies, financial institutions, and intermediaries to verify identity of clients, maintain records, and furnish information in prescribed form to Financial Intelligence Unit India, or FIU Ind. The PMLA Act was amended in the year 2005, 2009, and 2012. Section 45 of the PMLA Act 2002 provides that no person can be granted bail for any offence under the Act unless the public prosecutor appointed by the government gets a chance to oppose his bail. And should the public prosecutor choose to oppose bail, the court has to be convinced that the accused was not guilty of the crime and additionally that he or she was not likely to commit any offence while out on bail. It observed that the provision violates Article 14 and 21 of the Indian Constitution. On 24 November 2017, in a ruling in favour of citizens' liberty, the Supreme Court has set aside a clause in the Prevention of Money Laundering Act which made it virtually impossible for a person convicted to more than 3 years in jail to get bail if the public prosecutor opposed it. Let's take a look at the objectives of the Prevention of Money Laundering Act. The PMLA Act seeks to combat money laundering in India and has three main objectives. Number 1. To prevent and control money laundering. Number 2. To confiscate and seize the property obtained from the laundered money. And number 3. To deal with any other issue connected with money laundering in India. Some of the key definitions referred in this act are: attachment. Attachment refers to prohibition of transfer, conversion, disposition or movement of property by an appropriate legal order. Proceeds of crime. Proceeds of crime refers to any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offence. Money laundering. Money laundering refers to whosoever directly or indirectly attempts to indulge or assist other person or actually involved in any activity connected with the proceeds of crime and projecting it as untainted property. Payment system. Payment system refers to a system that enables payment to be effected between a payer and a beneficiary, involving clearing, payment or settlement service, or all of them. It includes the systems enabling credit card, debit card, smart card, money transfer, or similar operations. Some of the salient features of this act are: punishment for money laundering. The act describes that any person found guilty of money laundering shall be punishable with rigorous imprisonment from 3 years to 7 years, and where the proceeds of crime involved relate to any offence under paragraph 2 of Part A of the schedule, that is, offences under the Narcotic Drugs and Psychotropic Substance Act 1985, the maximum punishment may extend to 10 years instead of 7 years. The next feature is regarding the powers of attachment of tainted property. The director or officer above the rank of deputy director with the authority of the director can provisionally attach property believed to be proceeds of crime for 180 days. Such an order is required to be confirmed by an independent adjudicating authority. The next feature of this act is regarding adjudicating authority. The adjudicating authority is the authority appointed by the central government through notification to exercise jurisdiction, powers and authority conferred under the PMLA Act. It decides whether any of the property attached or seized is involved in money laundering. The adjudicating authority shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice and subject to the other provisions of PMLA. The adjudicating authority shall have powers to regulate its own procedure. The next feature of this Act is regarding the presumption in interconnected transactions. Where money laundering involves two or more interconnected transactions and one or more such transactions is or are proved to be involved in money laundering, then for the purpose of adjudication or confiscation, it shall be presumed that the remaining transactions form part of such interconnected transactions. The next feature regarding this Act is on burden of proof. A person who is accused of having committed the offense of money laundering has to prove that alleged proceeds of crime are in fact lawful property. The next feature of this Act is regarding Appellate Tribunal. An Appellate Tribunal is a body appointed by Government of India, and it is given the power to hear appeals against the orders of the adjudicating authority and any other authority under the Act. Orders of the tribunal can be appealed in appropriate High Court for the jurisdiction and finally to the Supreme Court. The next feature regarding this Act is the Special Court. Section 43 of Prevention of Money Laundering Act 2002 says that the central government, in consultation with the Chief Justice of the High Court, shall, for trial of offence punishable under Section 4, by notification, designate one or more courts of session as special court or special courts for such area or areas or for such case or class or group of cases as may be specified in the notification. The next feature is regarding Financial Intelligence Unit India or FIU-IND. The Financial Intelligence Unit India was set by the Government of India on 18th November 2004 as the central national agency responsible for receiving, processing, analyzing, and disseminating information relating to suspect financial transactions. FIU-IND is also responsible for coordinating and strengthening efforts of national and international intelligence, investigation, and enforcement agencies in pursuing the global efforts against money laundering and related crimes. FIU-IND is an independent body reporting directly to the Economic Intelligence Council EIC headed by the Finance Minister. Thank you very much for listening to this article on the Prevention of Money Laundering Act. For more such articles, install the UPSC Practice app from the App Store.